very good afternoon to Honourable Justice Hari Kumar Nair, Justice of the Court of Appeal, Supreme Court of Singapore, Honourable Justice Kalan Ramesh, Judge of the Appellate Division, Supreme Court of Singapore, Professor Lucian Bebchuk, James Barr Ames, Professor of Law, Economics and Finance, and the Director of the Programme on Corporate Governance at Harvard Law School, Professor Lee Pei Woon, Dean of the Yong Pung Hau School of Law, Singapore Management University, Professor Joe Hans, CJ Co-Professor and Director of the E.W. Barker Centre for Law and Business at the National University of Singapore, Professor Dan W. Puchniak, Yong Pung Hau Professor of Law and the Director of the Centre for Commercial Law in Asia at Singapore Management University, Assistant Professor Kenneth Khoo at the National University of Singapore, Mr. Zack Oswald, Partner at Jones Day, and distinguished guests, ladies and gentlemen.
Welcome to the Jones Day Professorship of Comparative and Commercial Law Lecture 2026, jointly presented by Jones Day, the Center for E.W. Barker Center for Law and Business at the National University of Singapore, and the Center for Commercial Law in Asia at Singapore Management University. My name is Yun Yao from National University of Singapore.
And my name is Amber from the Singapore Management University. We will be your MCs for this evening. It is our great pleasure to welcome all of you to this evening's lecture. We now invite Professor Dan Puchniak, followed by Assistant Professor Kenneth Khoo, to deliver the welcome remarks. Professor Puchniak, please.
Honorable Justices, distinguished guests, colleagues, friends, on behalf of SMU, Yong Pung Hau School of Law, and the Center for Commercial Law in Asia, I want to warmly welcome you to the 2026 Jones Day Professorship Lecture. I want to keep my comments short, but I would be remiss if I didn't offer at least 3 thank yous. The first thank you has to go to Jones Day. As somebody who spent 15 years at NUS, and I'm now almost 5 years at SMU, I can tell you that this is not the only event that Jones Day sponsors. They sponsor a myriad of things at both law schools, and they've done a great deal to advance the Singapore legal system. And for that, we're eternally grateful. And so I want to thank Zack and the entire firm of Jones Day for being such a generous sponsor. The second thanks, of course, has to go to the collaboration here. We have 2 wonderful, extraordinary law schools, 2 terrific law centers, the E.W. Barker Center for Law and Business and the Center for Commercial Law in Asia. And this is really a credit to the Singapore government. There's been such a wonderful ecosystem that has evolved in Singapore, in the legal academy, that has been bringing true talent from around the world. And this couldn't go on without the strong support for the legal academy and education in Singapore. And so I'm grateful to NUS and the center for coming together on this initiative. My final word of thanks is, of course, to Professor Bebchuk. I'm not going to steal Zack's thunder because he's been given the job of properly introducing Professor Bebchuk. So I'm just going to say for 1 minute on a personal note. When I woke up this morning and I thought of all the legal academics that I have had the pleasure and honor of learning from over the years, I honestly can say that Professor Bebchuk's work has taught me more than anyone in the field. And when I thought about why he's taught me more, he sees things that others don't see. But then I think when he sees those things, he describes them in a way that seems so simple. And after you read a paper, you say, that's so obvious. But it's only obvious because he saw it and described it so well. And I've had that feeling so many times. But perhaps more importantly, it's not just that unbelievable ability. It is that a thread running through his work is an integrity, an academic honesty, and a passion for scholarship. And it is that thread that I think makes it such an honor and privilege for us to welcome him for the first time to Singapore. So on that note, I want to thank you, Professor Bebchuk, for all of your work, for coming here today. And you couldn't be speaking on a more important topic in our field, and it's a true honor to host you here. With that, I will hand it over to Kenneth Khoo from the National University of Singapore, a good friend of mine, to deliver the remarks on behalf of NUS. Thank you very much.
Thank you so much, Professor Dan Puchniak. So, honorable justices, distinguished guests, ladies and gentlemen, good evening. On behalf of NUS Law, I'd like to give a few words of welcome. So I'll keep it very short, like Dan, just two instead of three thank yous. So the first thanks goes to Jones Day for his generous sponsorship of this lecture, in particular Sushma Jobanputra, partner in charge of Jones Day Singapore office. We are extremely grateful for Jones Day's continuing support, and we would also like to thank the other donors and supporters of the E.W. Barker Center for Law and Business, whose generosity makes this event possible. The second thanks goes to SMU's Center for Commercial Law and in Asia, and we're really grateful that Dan and so many other colleagues came together to make this event a success. I would like to add a personal note here, deviating from Dan's script, which is that in 2023, I had the personal privilege of being a fellow at the Program of Corporate Governance, which Professor Lucian Bebchuk heads. During this time at Harvard Law School, he was extraordinarily generous with his expertise, time, and guidance, and much of my current research direction is greatly influenced by him. This includes, among other things, my collaborations with his colleague and friend of mine, Professor Roberto Tallerita, who is now his colleague at Harvard Law School. As you may know, Professor Roberto is one of Lucian's former mentees. So it is a particular pleasure for me today to welcome Lucian to Singapore, and one of the most influential corporate governance scholars of our time, and someone whose mentorship has meant a great deal to me and to the world at large. Thank you very much, Professor Bebchuk.
Next, we'd like to invite Mr. Zack Oswald on stage to deliver his welcome remarks and to introduce our 2026 Jones Day Professor of Comparative and Commercial Law, Professor Lucian Bebchuk. So, Mr. Zack Oswald, please.
Hi, everyone. Good afternoon. I'm Zack Oswald, a corporate partner at Jones Day. I would promise to keep it short as well, but I have a long list of credentials and honorifics that I have to get through to introduce our guest speaker, so it may take me a little bit longer. I've been thanked too many times. I contribute little, but I appreciate everyone saying nice things about Jones Day. But it's my privilege to introduce our distinguished guest speaker, Professor Lucian Bebchuk. I'll take a few minutes to give a bit of background on him, and then I'm sure you'll all appreciate, what we have in store and how much we're looking forward to the remarks. As many of you know, Professor Bebchuk is the James Barr Amis Professor of Law and Economics and Finance and Director of the Program on Corporate Governance at Harvard Law School. He's also a Fellow of American Academy of Arts and Sciences, a Research Associate at the National Bureau of Economic Research, an inaugural Fellow of the European Corporate Governance Network, and a Director of the SSRN Corporate Governance Network. Professor Bebchuk's research focuses on corporate governance, law, finance, and economics, and he holds an LLM and SGD from Harvard Law School, as well as a master's and PhD in economics from Harvard Economics Department. To give you a sense of the scale of his works, Professor Bebchuk is the author or co-author of more than 100 research papers and is ranked by SSRN in terms of citations of his work as first. And by first, I should emphasize that this is across all the fields of legal academics. His writings include the widely acclaimed book, Pay Without Performance, An Unfulfilled Promise of the Executive Compensation. In addition to his contributions to scholarly articles, Professor Bebchuk has also authored numerous op-ed pieces in the Wall Street Journal, the New York Times, and the Financial Times. The impact of that body of work has been widely recognized, and he's cited as one of the nation's leading scholars of law and economics, and has made major contributions to the study of corporate control, governance, and insolvency. Turning to his other leadership roles, Professor Bebchuk serves as president of the Western Economics Association International, president of the American Law and Economics Association, and chair of the Business Association section of the American Association of Law Teachers. He has received numerous awards, recognitions, and rankings for his contributions and work in the field of law and economics, including receiving the Best Academic Paper Award and prize in financial research from the Investor Responsibility Research Center Institute. Among his impressive list of achievements, Professor Bebchuk has been listed as one of the 100 most influential players in corporate governance, one of the 100 most influential people in finance, and named one of the top 10 governance stars among various industry associations. Beyond his scholarly endeavors, Professor Bebchuk has also been deeply engaged in the policy arena. He's advised governmental bodies and contributed policy-making decisions, including appearing before the U.S. governmental hearings and roundtables, such as the U.S. Senate Finance and Banking Committees, the U.S. House of Representatives Committee on Financial Services, and the U.S. Securities and Exchange Commission. Professor Bebchuk's contributions extend to the private sector as well, and he served on the board of directors of one of the world's largest producers of nickel and palladium, and he heads the Shareholder Rights Project, which is a program that has represented public pension funds and charitable organizations in bringing about board declassification in more than 75 S&P 500 and Fortune 500 companies. It is, by any measure, a truly distinguished record, and I'm confident that we're in for an exceptional presentation. So without further ado, please join me in welcoming Professor Bebchuk, who will take us through 3 conceptions of capitalism.
Thanks, everyone. This is my first time in Singapore, and I'm delighted to be here. Thanks to Zack and Dan and Kenneth for the very kind introduction. They meant a lot to me, and I appreciate them. Thanks also to Jones Day for sponsoring this lecture series. My topic is 3 conceptions of capitalism. For the lawyers in the audience, I apologize, it's not going to touch directly on particular doctrines of corporate law, which is my usual day work, but it does touch on debate that has been going on for a long time, has reached a certain peak in recent years, although it has subsided a bit, but I expect not for long. So what the work that I will be discussing does is it tries to provide a framework for how to think about alternative conceptions of capitalism. I will use this framework to discuss and explain, based on my own research work, why I support one of those conceptions and reject or do not support the others. I will be talking about stakeholder effects in general. As you know, companies have a wide range of stakeholders: employees, creditors, communities, the environment, climate risk, and so forth and so on. I'll talk about them in general, but I will illustrate climate and employees. I'll use them as examples. So what are the 3 conceptions I will be talking about? I'll talk about them as Friedmanesque capitalist, managerial stakeholderist, and democratic capitalist. I choose those 3. I'll have something to say also about other conceptions that some academics have put forward and the problems I view with them. But I will focus here on the 3 conceptions that have had considerable traction, not just in academia and thought leadership, but also in the quote-unquote real world of political and business practice. Friedmanesque capitalist, probably familiar to all of them, it's the approach that provides support for a laissez-faire form of capitalism that has 2 elements. One is that corporations should have an exclusive focus on the profits of shareholders, the value of their shares, and that this shareholder-focused operation should go alongside a limited role government. And I name it after Milton Friedman there on the upper right-hand side. It has been supported also by others at the Chicago School of Economics. Managerial stakeholderism, there are the photos of some key leaders. It's a view that advocates encouraging corporate leaders and relying on them to use their discretion not only in the service of shareholders, but also that of stakeholders. The pendulum has been swinging various times over the decades, but in the last decade, this view has received substantial support among corporate leaders and management groups. This was expressed in the Business Roundtable Statement on Corporate Purpose in 2019, in the Davos Stakeholder Capitalism Manifesto the year after. And during the COVID pandemic, it seemed like support for it peaked, though support has since then somewhat subsided, and would be interesting for you to reflect on why that has been the case, and I'll be happy to talk about it. A word about alternative versions of the managerial stakeholderism that I will be discussing and questioning. There are two versions of it. One version, and this is a distinction that my work with Roberto Talarita emphasized. One version is that of instrumental stakeholderism. And that's one that prescribes that corporate leaders take stakeholder interest into account if and only when that doing so would serve stakeholder value. So it would say to corporate leaders, look, if you don't treat employees well, that would hurt you in the long term, and therefore you should do so. But it uses stakeholders as an instrument to obtain higher shareholder value. And sometimes this version of capitalism is referred to, especially in the UK, as quote-unquote enlightened shareholder value. Another version is that of pluralistic stakeholderism. There, stakeholders have independent value and independent weight. Corporate leaders are supposed to give an independent weight to them and are supposed sometimes to be willing to sacrifice shareholder profit in order to advance the interest of stakeholders. Those versions are importantly different, but there is one way in which they are importantly similar, and that is that both of them emphasize the discretion of corporate leaders. They don't seek to replace the discretion of corporate leaders with any mandate. It wants to rely on this discretion, and as long as the discretion is there, and as long as we have the business judgment rule, which means that courts are not going to scrutinize the decisions of corporate leaders substantively, even though there are some important differences between those two versions, practically they might amount to the same thing. And in evaluating this thing, in evaluating how well stakeholderism will work, the practically important question is, how should we expect corporate leaders to use this expanded discretion to look at stakeholder interest and not only shareholder interest? Let me turn to democratic capitalism, the third conception. The work that I've done in recent years falls within this conception. What characterizes supporters of democratic capitalism? Like stakeholderists, and unlike supporters of Friedmanesque capitalism, they have deep concerns about corporate externalities, about what happens to stakeholders in a laissez-faire economy. But unlike supporters of managerial stakeholderism, they are skeptical that corporate leaders should be expected to use discretion to serve stakeholders. Their view is that to make capitalism work for stakeholders and for society in large, what we should support are two elements. One element is adopting external laws and regulations that from the outside would constrain and incentivize corporate leaders to take stakeholder interest into account. So for example, in addressing climate risk, we might turn to carbon taxes or subsidies, or we might have various labor protecting rules and regulations in order to address negative externalities with respect to employees. And the other supportive element is that to enable the first element to be carried out, we should limit corporations from getting too much involved, too influential in the democratic process in a way that could impede the adoption of regulatory constraints on corporations. How should one choose among those three conceptions in trying to form a judgment on those questions, which any of you might want to do? I suggest that there are 4 questions that you might want to ask yourself, and the type of answer that you will give should guide your choice among the rival conceptions. One question is, how well is laissez-faire capitalism working for stakeholders? One possible answer is reasonably well. That's a view that sees the stakeholders here on the right dancing happily. And that's the view of Milton Friedman, who said, I quote him here, "The free market system is the secret of the enormous improvement in the conditions of the working person." Not everybody has everything they want, but we can't have another system that would work better. Now, the other 2 views think that even though they recognize the power of the market system, they recognize the importance of negative externalities vis-a-vis stakeholders, and they believe that the laissez-faire system doesn't work so well for stakeholders. And both managerial stakeholderists, I quote here Rebecca Henderson, she says the world is on fire, and democratic capitalists have the same view that we should be concerned about corporate externalities. So each one of you might have a different answer to this question, might have a different sense. The closer one of you is to the quote-unquote well answer, the more you should view yourself as being pulled to Friedmanesque capitalism and away from the other 2 conceptions. And conversely, if you think that it's not working well, you should find yourself pulled away from Friedmanesque capitalism and towards the other 2 conceptions. Second question is, if we give discretion to corporate leaders, which is what is encouraged, advocated by the supporters of stakeholder capitalism, and the question is, can we expect corporate leaders to make substantial use of this discretion to protect stakeholders rather than serve their own interest or some other purposes? Managerial stakeholderists are optimistic about this. They believe that corporate leaders can be expected to do so. Friedmanesque capitalists are worried that giving discretion or having this as a norm might be abused by corporate leaders to do this. They don't like it, but they think that corporate leaders will move towards stakeholders. But democratic capitalists, as I will discuss with you, think that that's not the case because incentives matter, and incentives are not going to be used, are not going to lead corporate leaders to use their discretion to serve stakeholders. So again, the answer that you give where you are on the continuum from yes to not at all will determine which conception you are pulled to or pulled away from. The third question is, are government interventions both feasible and beneficial? And as you all know, people have very different views, very different intuitive judgments on this question. The answer no is given by Friedmanesque capitalists. They believe that government interventions are not a solution to anything. They believe they are largely a problem. Managerial stakeholderists might not be as negative, but they're not supporters of governmental interventions because they like to have a private ordering solution, and they believe that giving expanded discretion to corporate leaders would do that. Democratic capitalists are more optimistic about governmental intervention working, and that shapes their view. The fourth and the last question is whether we believe that corporate politicking, by that I mean corporate intervention in the political process, corporate attempts to shape the outcome of the political process, either by lobbying or by campaign financing or whatever, is this largely detrimental or not? Democratic capitalists think that that's detrimental because it weakens the ability of democracy to constrain and regulate corporate behavior, which is what we want the government to do. But others have the opposite answer. Friedmanesque capitalists think that corporate intervention in politics is not only acceptable, but it's actually desirable because it's a constraint on the Leviathan, on the government whose intervention we have reasons to fear. And managerial stakeholders are not as adversarial, but they do take corporate politicking as given, and they do not attach priority to limiting it. Their focus is elsewhere. Because I'll be explaining to you my support for democratic capitalism, I would like to compare it briefly to the two other conceptions. So one point that many in academic writings or in the media, I cite here a Financial Times article, when the debate on stakeholderism was at a peak, people try to conflate those two conceptions, democratic capitalism and Friedmanesque capitalism, as both opposed to stakeholderism. They were viewing both of them as shareholder-friendly rather than stakeholder-oriented. But I would like to suggest to you that this conflation is very much unwarranted, that democratic capitalists differ from Friedmanesque capitalists in three key ways. One is they have a very different view as to how laissez-faire works and how it treats stakeholders. They have different views on what role they would like the government to play, and they differ in whether they support or oppose corporations' participation in the political process. So yes, both of them are not enthusiastic and indeed reject discretion for corporate leaders to benefit stakeholders, but they're otherwise fundamentally different. Let me also say a couple of words about how democratic capitalism differs from managerial stakeholderism. And there are two ways in which certainly supporters of managerial stakeholderism might say that it's not all that different from democratic capitalism. One is some people say, look, stakeholders, like the people that I showed you on the earlier picture, Jamie Dimon, who was influential in the adoption of the Business Roundtable statement, or Martin Lipton, who has been advocating this view, or the head of the Davos World Economic Forum. Somebody might say, well, they are not really opposed to governmental reforms. They just want to supplement them with private ordering help by harnessing the discretion of corporate leaders. But if you look at those views more carefully, you see that business sector supporters of stakeholderism often put it forward as a substitute for governmental reform. Indeed, they are suggesting this might be the best way to avoid governmental intervention. So the argument is we need to do this because otherwise the pitchforks will arrive. Otherwise, governmental interventions will come, and unless we ourselves take care of stakeholders, we should. This would be the only way to avoid it. It might be argued that stakeholders are not opposed to limits on corporate politicking, but if you look at their writings and their statements and what they advocate, you see that they take corporate politicking as inevitable, as acceptable, as part of the premise we should take as given. Indeed, many of the supporters of stakeholderism say that because there are impediments to governmental intervention, say there is a political gridlock, that's a main reason why we should go for stakeholderism. This is, for example, an argument strongly made by Colin Mayer from Oxford. And they use their energy, those of them who are active in the real world, they use their energy to engage with corporate leaders, but not to try to push the government for legal regulatory reforms. Last comment on the alternative conceptions, I wanted to say that some of you might give different answers to those four questions depending on the context, depending on the category of the stakeholders that we are talking about. So some of you might think that for suppliers, the market protects their interest sufficiently well, and for the environment or climate risk, the market doesn't protect things sufficiently well, and therefore they might adopt a different conception for a certain area of the law, like the law governing supplier-client relationship than the law governing, say, the environment. Okay, let me turn to the next thing I would like to do is to explain, even though people can give different answers to those four questions, and they can reasonably disagree about them, and therefore I do not expect, I expect most of the people here to differ in the conclusions they reach, why I myself support democratic capitalism and reject managerial stakeholderism, why I reach this judgment. Overviewing, summarizing a series of papers. They are all available on SSRN or my website. If any of you downloads them and looks at any of them, God bless you. If not, that's okay. You're busy. God bless you anyway. So there are two elements to this work. One is the claim that the benefits of stakeholderism are really illusory. Giving discretion to corporate leaders is not going to protect stakeholders. And that is because if you look carefully at the incentives of corporate leaders, you see that they have an array of incentives. arising from the different markets within which they operate, the market for corporate control, the market for managerial labor, the product market, and so forth. And if you analyze these incentives in detail, you see that corporate leaders really have incentives not to serve stakeholders beyond what would serve shareholder value. There are some claims that some people have made that even though a standard analysis would reach this conclusion, there might be some developments that would lead us to qualify it. Many companies have, in the past decade, adopted ESG-based pay arrangements. They have withdrawn a little bit when the interest in ESG has subsided most recently. And the suggestion was, well, when you have ESG-based compensation arrangements in place, then it's no longer the case that corporate leaders do not have incentives to use their discretion to serve stakeholders. To the contrary, they will have such incentives. In work that we did, we concluded that the promise of such arrangements is actually highly questionable. As an empirical matter, we find by looking at all the ESG compensation arrangements in the S&P 500, we find that current practices, the ones that have been followed, really provide corporate leaders with performance-insensitive pay that is hard to explain as providing meaningful incentives to serve stakeholders and are best explained as attempts to increase corporate leader payoffs. The essential problem is that outside investors have a great deal of difficulty to scrutinize ESG-based compensation. And the lesson of corporate governance in the last 20, 30 years was that monitoring by outside investors is extremely important for constraining pay. And moving to ESG-based compensation actually reverses this positive trend because it leads to separating pay from performance without really producing benefits from stakeholders. There is another argument that some of you might have heard or think about it intuitively, and that is that maybe some corporate leaders have incentives that are provided by the pro-social preferences of employees and customers. When that's the case, then corporate leaders, in order to attract employees or customers, would have incentives to treat stakeholders well. But to the extent that this is the case, that's not really a reason to think that corporate leaders will behave differently from what they would be asked to do under Friedmanesque Capitalism. Because Milton Friedman, if you stipulated to him that, look, in this company, the employees would be willing to work less if you treat the environment more nicely, or that people will buy more pizza from your company if you behave in a certain way, then you would say, look, I don't understand why they have preferences, but if that's the case, let's serve those preferences, because from the narrow perspective of shareholder profit maximization, that's the right way to go. And the problem is that even within Friedmanesque capitalism, pro-social preferences might lead some companies to quote-unquote behave well vis-a-vis stakeholders, in many other circumstances, that would hardly move the needle, and I listed here some reasons why this is the case. And lastly, there is an argument that was given a lot of weight by various observers 2, 3, 4 years ago, when some of the institutional investors were expressing a great deal of allegiance to ESG, that in order to please institutional investors, corporate leaders will have incentives to take the interests of stakeholders into account. In our writings that we did or are currently doing, we reached the conclusion that that's the case because institutional investors themselves also do not have incentives to serve stakeholders beyond what would serve shareholders, but they might have incentives for various reputational reasons to talk in this way, but not really to push companies to move in this direction. So they have incentives to talk a lot about ESG, but not to provide stakeholder benefits. And this kind of analysis is actually consistent with institutional investors withdrawing in the last couple of years from the ESG talk, given the change in the environment. Let me turn now to the second leg of this work and describe to you some empirical evidence in a series of empirical studies that we put forward, evidence that supports the conclusions of the incentives analysis, evidence that indicates that stakeholder talk by corporate leaders has been mostly for show. And this is even the case when corporate leaders engage in a very substantial stakeholder rhetoric, and even when corporate leaders are allowed to have substantial discretion to protect stakeholder interests. One study that we did was to contact all the companies whose CEOs joined the Business Roundtable statement on corporate purpose, and to ask them whether this received approval by their board. If the companies were to think that this is an important major endorsement that would lead the companies to be meaningfully constrained to act in a different way than what they've done before, then as is standard in governance practice, we would expect the CEO to get board approval or to consult with the board before signing such a statement. But fortunately for the paper, dozens of companies responded, and all but one said that this was not brought at all to the board. We also documented how companies, the same signatories of the Business Roundtable statement, how they have acted in the several years that passed since the joining of the Business Roundtable statement. And we saw that generally those companies left in place without any change corporate governance guidelines that express strong commitment to shareholder primacy, left the compensation of directors exclusively linked to shareholder value without any link to stakeholder metrics. And then when shareholder proposals were submitted to a vote, asking the companies to explain or to report what changes they made following their joining and endorsing the Business Roundtable, the companies in their securities filings responded by stating that no changes were planned or needed in light of this signing of the BRT statement, which was kind of inconsistent with the fact that the BRT statement at the time, if you look at the media coverage, the words that were used about this, that this was historical milestone. It was an event that was going to transform the landscape of governance. We also did an empirical study of how corporate leaders use their negotiating power, the discretion they have when they sold the companies to private equity buyers. And we did this study over 2 decades, looking at such sales over 2 decades. And we chose to look at it for companies that were incorporated in states that explicitly allowed the use of discretion to give weight to stakeholder interest. And kind of going over both the M&A agreements and subsequent coverage, we found that corporate leaders generally obtained and used their bargaining power to increase the initial premium offered and sometimes to serve the private interest of the corporate leaders themselves. But there is little evidence that they used any of their bargaining power to obtain protections for the interests of employees or any other stakeholders. We reached a similar result when we looked at the massive number of M&A transactions that took place during COVID. Everyone here who lived through this period, it was a bad period for people personally, but it was a great period for the M&A industry. There was a massive number of, as well as for the stock market. There was a great deal of M&A transactions. And actually at the time, there was also a great deal of rhetoric because stakeholders were especially vulnerable in this period. And there was a great deal of stakeholder rhetoric at the time. But again, looking at the documents accompanying those transactions, we found, again, lots of use of bargaining power to serve shareholders in the private interest of corporate leaders, and no use of this bargaining power to get benefits or protections for stakeholders. Quickly saying, this is just a particular example of the point earlier. We did a case study analysis of Elon Musk's acquisition of Twitter, now called X. Some of you might have followed this acquisition at the time. Twitter, prior to the acquisition, was a company that engaged in a great deal of stakeholder rhetoric. It expressed a commitment to employees, which they called the TWIPs, and a lot of values, like values to certain kind of conversation and monitoring and so forth and so on. But if you look at what happened at the acquisition, when it came to the negotiation of the acquisition, even though they could have done it, the corporate leaders of Twitter did not use their power in any way to protect the values to which Twitter expressed commitment prior to the transaction. And this is not, by the way, I know that lots of people like to criticize Elon Musk these days, or those days in the past, but this is not criticism of Elon Musk. He was doing what he thought was good for his interest. This is really questioning whether the corporate leaders of Twitter, who expressed this strong commitment to stakeholderism over many years, really delivered on this. Let me turn to the perils of stakeholderism, because many of you might think, look, even if stakeholderism should not be expected to deliver a great deal of value, it can't hurt, can it? At the minimum, it might move things only in a positive direction. But the reason why we did not think so and wrote so many pages describing our concerns is that acceptance of stakeholderism in any period, in our view, would be counterproductive because it would produce 2 major costs. The first cost is reduced accountability by corporate leaders, because it seems that various corporate leaders used stakeholderism to urge institutional investors to be more deferential to corporate leaders, less supportive, for example, to activists when they came around. The idea being, don't pressure us, don't side with activists, so that we can have a free hand to take care of stakeholders in the long run. And you find it in a lot of expressions by support managerial or management groups supporting stakeholderism. If this is the case, then the outcome would be reduced accountability. It wouldn't help stakeholders, but it would raise managerial slack, which might benefit the private interest of managers, but would not serve either shareholders or stakeholders. The other adverse effect is that to the extent that society or substantial part of it accepts stakeholderism and buys into it, that might reduce motivation to push for governmental reforms that would take the interest of stakeholders into account, because the view would be we don't need to intervene. We can just wait and see. Private ordering and corporate leaders will take care of the problems. This happened, for example, in the climate context, when some public officials, in light of the net zero pledges that many corporate leaders adopted, so that they can, to some extent, rely on corporate leaders to address climate problems. Now, some of you might accept some of what I said before, perhaps even much of it, but might say, look, government solutions might be realistic. We have politics, we have sometimes political gridlock, we have interest group politics. But what I would like to suggest to you that you should not support stakeholderism, even if you are a skeptic of how often we can get a beneficial government intervention. Because the message of this talk is not that democratic capitalism can always work in any democracy at any time, but rather that stakeholderism cannot work. Stakeholderism is not a viable way on which we can count to protect stakeholders, and only democratic capitalism can hopefully sometimes do so. And to the extent that we believe this, then we should focus on it, and sometimes it will work, sometimes it might not, but that's the only viable route. There are, and this might come up, but I am running out of time and I would like to hear questions. I have also a part in the written work that looks at what I call non-managerial stakeholderism. And those are approaches that have not had much traction in the real world, but academics have developed, put forward, advocated. And those things are not based on giving managers or corporate leaders more generally more discretion and relying on this, but rather on otherwise hard kind of interfering with the internal rules of corporate governance in a way that would push corporate leaders or force them to do so. Everything okay. By, for example, amending fiduciary duties so that they mandate taking stakeholder interest into account rather than just allowing it, or placing representatives of various stakeholders groups on the board, or having forwarding some choices to shareholders or to the beneficial investors of institutional investors. But there are reasons to believe that none of them would work too well, and I'll be happy to talk about it. And I basically wanted to leave on the table for our discussion that even if you care about stakeholders, so even if you are a fan of stakeholders, even if your heart goes for stakeholders and you think that there are corporate externalities and we have to worry about them, you should not be tempted by the siren song of stakeholderism, because stakeholderism is not going to provide real benefits to stakeholders. If anything, it would hurt shareholders, it would hurt corporate efficiencies, it would hurt society. It might only help the private interest of corporate leaders and chill the potential for reforms. And that the only viable way, not the certain way, but the only viable way is not to count on the discretion of corporate leaders, but rather to follow the path of democratic capitalism, sometimes with success and sometimes not. Oh, actually, I got back the final slide, so we do have it. Thank you very much.